All right, so we have finished from section 17 to section 23 of Indian Evidence Act. ठीक है, 17 में डेफिनेशन है, 18 से 20 तक who may give admissions, 21 में रेलेवेंसी है, कौन सी एडमिशंस रेलेवेंट है, सारी एडमिशंस रेलेवेंट है, बट कौन सी एडमिसिबल है, किनको प्रूव कर सकते हैं, किनको प्रूव नहीं कर सकते हैं, 21 में दिया है। ठीक है, उसके बाद फिर 22 और 23 ये किस चीज की बात कर रहे हैं? 22 इज टॉकिंग अबाउट ओरल एडमिशंस। ओरल एडमिशंस को हमने इंटरलिंक किया विद सेक्शन 63, 65, 91, right? And especially 63 subsection 5. All right, oral accounts. Oral accounts, oral admissions में difference एक question बन सकता है। ये वाला आपका टॉपिक मेंस के लिए इंपॉर्टेंट है। आपको सब्जेक्टिव अगर आता है एडमिशन पे तो आपने ये पूरा 17 to 20 देना है। रेलेवेंसी पे भी क्वेश्चन आता है। 22 ओरल एडमिशंस अभी तक क्वेश्चन नहीं आया है, प्री में ही आता है, बट मेंस में आ सकता है। ओके, यू मे गेट अ क्वेश्चन। एंड 23 टॉक्स अबाउट रेलेवेंसी ऑफ एडमिशंस इन सिविल केसेस। कब एडमिशन जो है सिविल केसेस में रेलेवेंट है? दे आर रेलेवेंट, but they will be not relevant in case the parties have even written or expressly stated that they should not be used in admission. Right? Expressly stated that they should not be used in admission. उस केस में, so यहाँ पे 23 is talking about civil cases. Civil cases. Civil cases में admission जो है वो relevant है, but दो situations दी है जब civil cases में admission जो है relevant नहीं होंगी। ठीक है, जहां पे कोर्ट कैन इन्फर या फिर पार्टी ने एक्सप्रेसली दिया। और 22 के अंदर बेटा आपने दो सिचुएशंस देखनी है जहां पे ओरल एडमिशंस जो है क्या होंगी? रेलेवेंट होंगी। अदरवाइज जनरल रूल क्या है? ओरल एडमिशंस रेलेवेंट नहीं है। बट ओरल एडमिशंस रेलेवेंट कब होंगी? जब उसका जेन्युइननेस चैलेंज किया गया पार्टीज ने, या फिर सेकेंडरी एविडेंस हैज बीन अलाउड बाय द कोर्ट, राइट, उसको corroborate करने के लिए। सो इतना पार्ट सबको क्लियर है? ठीक है, then along with this we also did that admissions are only conclusive proof। इसको हमने कल बड़े अच्छे से जो है ब्रेक डाउन करके समझा कि अगर मैंने एक चीज एडमिट भी की है, जिस पर्सन ने एडमिशन दिया भी है, तो इसका मतलब ये नहीं है कि वो जो उसने एडमिशन दिया है वो प्रूव हो गया। वो अगर चाहे कोर्ट में आके उस एडमिशन को डिस्प्रूव करना चाहता है तो वो डिस्प्रूव कर सकता है, क्योंकि वो कंक्लूसिव प्रूव नहीं है। वो डिस्प्रूव कर सकता है, वो एविडेंस दे सकता है। और उस एक्नॉलेजमेंट के ऊपर अगर दूसरी पार्टी भी चाहे उसको डिस्प्रूव करना, तो ऑपोजिट पार्टी भी एविडेंस दे सकती है उसको डिस्प्रूव करने के। आर यू अंडरस्टैंडिंग? बट वहां पे फिर एक एक्सेप्शन नहीं देंगे, बस कंटिन्यूशन में दिया है कि क्या, कि अगर आप रिबट कर सकते हो जो आपने एक्नॉलेज किया है, ठीक है, बट जो आपने एक्नॉलेज किया है उसकी वजह से दूसरी पार्टी ने अगर अपनी लीगल पोजीशन चेंज कर दी है, तो फिर वो जो रिबटेबल एविडेंस है, वो जो रिबटेबल एडमिशन है, जो रिबटेबल एक्नॉलेजमेंट है, आप उसको रिबट नहीं करेंगे, तो फिर वो रिबटेबल इररिबटेबल हो जाएगा। हमने ये लास्ट में डिस्कस किया। उसके बाद फिर हमने एक छोटा सा कॉन्सेप्ट जो मैंने क्लैरिफाई किया था, दैट वाज ऑन डीम्ड एडमिशंस, या फिर जो क्वेश्चन था इन हरियाणा, that silence may amount to admission. That was a good question. Silence. Some students I saw have sent their script admissions, right? So this is all we had discussed yesterday, and we noticed one thing, that since we are doing admissions, ये सारे कौन सी admissions हैं? ये है extra judicial admissions. These are extra judicial admissions. एक्स्ट्रा जुडिशियल एडमिशंस कौन सी होती हैं बेटा? Extrajudicial admissions are those admissions which are not given in the judicial proceedings, not in the course of judicial proceeding, not given before the court. So ये extrajudicial admissions है. But there are some admissions which are also given before the court. There are some admissions which are given before the court, or the admissions in the proceedings of the court. उनको हम कहते हैं judicial admissions. So please, all of you can give the heading judicial admissions. Judicial admissions. Judicial admissions, Section 58 of Indian Evidence Act. Section 58 of Indian Evidence Act. Okay. So extrajudicial admissions as per judicial admissions as per Section 58, judicial admissions, it says facts admitted need not to be proved. Underline facts admitted. जो fact आपने admit कर लिए हैं need not to be proved. Now you compare this marginal heading जो अभी आपने पढ़ा बेटा with Section 31. वो 58 क्या कह रहा है? Facts admitted need not to be proved. Right? और Section 31 on the other hand क्या कह रहा है? Admissions are not conclusive proof. Not conclusive proof. मतलब जो फैक्ट्स आपने एडमिट किए हैं उसको आपको प्रूव करने की जरूरत नहीं है ना. नीड, आई मिस्ड ऑन not to be proved. Not to be proved, right? Can you see on the screen? What have I mentioned? Facts admitted. Facts admitted मतलब admissions, acknowledged facts need not to be proved. But 31 क्या कहता है? Admissions are not conclusive proof. Not conclusive proof मतलब
you need to prove them.
You can prove them, you can disprove them, you can give evidence. Not conclusive proof का interpretation क्या हुआ कि आप उसको they are rebuttable evidence. Rebuttable evidence. That means, can you see the major difference between judicial admissions and extrajudicial admissions? Just from this, extrajudicial admissions are rebuttable. You can disprove them. When I said to A that आज मैंने विनी के साथ कॉन्ट्रैक्ट किया और उस कॉन्ट्रैक्ट में मैंने ये घर खरीदा उसके साथ, अब वो सारी चीजें मैंने अगर ए को बताई है वो क्या है? एडमिशन है ना, एडमिशन है. बट वो मैंने एक प्राइवेट पर्सन को बताया है, आउटसाइड द कोर्ट बताया है. अब वो मैं रिबट भी कर सकती हूँ कि नहीं, मैंने जो भी उसको बताया, नाउ दैट एडमिशन कैन बी यूज्ड अगेंस्ट मी. That admission can be used, but we can give, it is a rebuttable evidence. It is a rebuttable admission, we can say. It is a rebuttable admission. But जो आपकी judicial admissions हैं, जो facts आप कोर्ट में Section 58 बोल रहे हैं, जो facts आप admit कर रहे हो, they need not to be proved. उनको prove करने की जरूरत नहीं है. उनको prove करने की जरूरत नहीं है. Like for example, आप कैसे आप कोर्ट में कैसे आप prove कर रहे हो fact? अब आप ये देखो बेटा, ये प्लेंट है आपकी. प्लेंट में आपने कुछ एलिगेशंस दूसरी पार्टी के अगेंस्ट आपने कुछ एलिगेशंस इम्पोज किए ना बेटा, और जिससे आप कॉज ऑफ एक्शन आपका राइज हो रहा है, तो वही आप नरेट करोगे ना प्लेंट में, वही आपके फैक्ट्स होंगे. और फिर प्रेयर में आप अपना जो आपको चाहिए वो आप मांगोगे. अब WS के अंदर आप क्या करोगे? आपने इसको एडमिट किया, इस फैक्ट को, ये वाले फैक्ट को नॉट एडमिटेड, ये वाले फैक्ट को नॉट आंसर्ड. तो अभी हम किसकी बात कर रहे हैं? कि जो आपने इसको एडमिट किया, दिस फैक्ट, ये फैक्ट जो आपने एडमिट किया है ना, दिस नीड नॉट टू बी प्रूव्ड. बट ये फैक्ट जो आपने नॉट एडमिटेड, इस पे इश्यूज बनेंगे, ये प्राइमरी फैक्ट्स होंगे, यहीं से कॉज ऑफ एक्शन अराइज होगा। आर यू अंडरस्टैंडिंग? एंड नॉट आंसर्ड, यस पारुल, जहां पे यू हैव नॉट आंसर्ड एन एलिगेशन, उसको क्या कहेंगे आप?
Ma'am, admitted.
What will you say? Admitted?
Yes,
Yes,
ma'am.
you are correct. Use the appropriate term.
Deemed to be.
Yes, deemed admissions. ये भी deemed admissions है। अब where is Dipansh?
Yes,
Silence
ma'am.
may sometimes amount to admission. You did not answer. Are you understanding, all of you? प्लेंट में आपने कुछ एलिगेशंस, अक्षता आपने प्लेंट बनाई, आपने उसमें फैक्ट्स दिए, उसमें आपके 5 फैक्ट्स थे। आपने कहा कि इस दिन में दिव्या के साथ आपका कॉन्ट्रैक्ट हुआ, इतने आपने लेन देन था, इतने को फर्स्ट जाना था, फिर सेकंड इंस्टॉलमेंट, वॉट एवर इट इज, तो आपने उसमें वो प्लेंट में जो भी, अब दिव्या जो है अपनी रिटन स्टेटमेंट के अंदर कुछ आपके फैक्ट्स को एडमिट करती है, कुछ एडमिट नहीं करती, कुछ का आंसर ही नहीं करती है। दैट इज साइलेंस। तो उसको हम कहते हैं डीम्ड एडमिशन। दिस कॉन्सेप्ट इज ऑल्सो गिवन टू यू अंडर ऑर्डर 8। ऑर्डर 8 में है ना ये आपका? यस, ऑर्डर 8 एंड इवन प्रोबेबली ऑर्डर 6 ऑल्सो। ऑर्डर 6 और ऑर्डर 8 में है आपका, सीपीसी में है आपका, ठीक है। यू हैव टू क्रॉस चेक, जब अभी हम सीपीसी करेंगे देन वी आर गोइंग टू टॉक अबाउट डीम्ड एडमिशंस आल्सो देयर। सो डीम्ड एडमिशंस, दे आर डीम्ड एडमिशंस। बट अभी हम 58 में किस चीज की बात कर रहे हैं? वी आर टॉकिंग अबाउट दिस पार्ट, वी आर टॉकिंग अबाउट एडमिटेड पार्ट। फैक्ट्स व्हिच आर एडमिटेड नीड नॉट टू बी प्रूव। जो फैक्ट्स एडमिट कर रही है उसको प्रूव करने की जरूरत नहीं है। इज एवरीबडी क्लियर विद द मार्जिनल हेडिंग? ठीक है, नाउ वी गो फॉरवर्ड, वी सी इट सेज नो फैक्ट नीड टू बी प्रूव्ड इन एनी प्रोसीडिंग। सर्कल द टर्म्स प्रोसीडिंग। किसी भी प्रोसीडिंग के अंदर आपको फैक्ट प्रूव करने की जरूरत नहीं है। which the parties dare to underline dare to, which the parties dare to मतलब आपस में, or their agents agree to admit। parties dare to मतलब parties in between themselves or their agents they agree to admit at the hearing। underline admit at the hearing। अब यहां लिख लो judicial admissions। when you admit outside the court, not in the proceedings, not in the hearing, that is extrajudicial admissions। So please, under these are the key words: proceedings, at the hearing. You are agreeing to admit, but where? At the hearing। ऐसा कुछ 17 में दिया है? कोई प्लेस दिया है 17 के अंदर? There is no place given ना। 17 सिर्फ क्या बोलता है? Statements having an inference to the fact in issue relevant fact, right? It does not say कि कहाँ पे। So when it is in the proceeding, then that is a judicial admission, okay? Or
Ma'am,
which
here agent, ma'am, here the term agent means lawyer as well, right?
agents mean what, beta?
Ma'am, over here it says the party hereto or their agents. They agree to admit at the hearing. So their agents include their lawyers if the lawyers admit a
Yes,
certain fact.
that lawyers. Lawyers. Which before the hearing they agree to admit by any writing. Underline. Before the hearing they agree to admit by ये this is the example। ये hearing से पहले WS में उन्होंने क्या कर दिया? They have agreed to admit। ठीक है, under their hands or which by any rule of pleading। underline rule of pleading। pleadings क्या होती है? yes Vinny, say बेटा।
Ma'am, order 6.
rule 1 defines pleading as
Plaint and written statement.
plaint and written। plaintiff की pleading है plaint और defendant की pleading है WS। ठीक है, so rule of pleading in force at the time they are deemed to have admitted by their pleadings। underline deemed admitted by the pleadings, इसको हम कहते हैं admission by pleadings। जब आप कोर्ट में कुछ कह रहे हो तो इन केस यू कम अक्रॉस दिस टर्म एडमिशन बाय प्लीडिंग्स, तो ऐसे मत सोचना कि हमने तो किया ही नहीं है. You're admitting something by pleading. When you're admitting something in the proceedings, in the hearing, then it is admission, judicial admissions. When you're otherwise giving any admissions, then it is extrajudicial admissions. So when we अभी जब 58 पढ़ने के बाद हमें सिंपल सा एक चीज समझ में आती है कि 58 कहता है कि अगर पार्टीज ने या उनके एजेंट्स ने कुछ भी प्रोसीडिंग्स में एडमिट किया है या फिर कुछ भी कोर्ट में एडमिट किया है या प्लीडिंग्स के थ्रू एडमिट किया है, इन राइटिंग एडमिट किया है, उसको प्रूव करने की जरूरत नहीं है. इतना कह रहे हैं ना, ये उसको प्रूव करने की जरूरत नहीं है. बट आगे उसके प्रोवाइजो एक्सेप्शन है. प्रोवाइजो सेज provided that the court may, underline may, in its discretion, require the facts admitted to be proved otherwise than on such admissions. मतलब even if you have admitted the fact but court को लगता है कि अभी क्या चाहिए, they need to be proved, then the court may require evidence. Are you understanding? So that is an exception to the general rule. Okay. So I think we can start writing section 58. Is all of you can write. Yes, Akshita.
Ma'am, just to be more clear, ma'am, for example, a person in a suit or proceeding has admitted that I have done so and so crime,
I
but
had
done so and so crime, offense.
offense तो उसमें बेटा WS थोड़ी ना आएगी.
तो वही मैम, सिर्फ और सिर्फ जो रिटर्न स्टेटमेंट में जो एडमिट कर रहा है बस उसी की बात कर रहे हैं यहाँ पर, या फिर जो प्रोसीडिंग में कहीं पर भी वो
प्रोसीडिंग्स तो जी, प्रोसीडिंग अलग हो गया, प्लीडिंग्स अलग हो गया. आप कोर्ट में आके कह रहे हो कि मैंने ये चीज की है. जी, तो उससे पहले अगर तो आप कोर्ट में आके कह रहे हो, अगर इन्वेस्टिगेशन स्टेज में कहा है तो वो कन्फेशन है. अगर आपने चार्ज फ्रेमिंग के टाइम का है तो प्ली ऑफ गिल्ट है. सिविल केसेस में WS में आपने कहा है. आर यू अंडरस्टैंडिंग? ठीक है. तो दे आर डिफरेंट, एज पर डिफरेंट प्रोसीडिंग्स यू विल हैव टू टेक डिफरेंट टाइम पीरियड जहां पे आप एडमिट कर सकते हो. ठीक है. ऑलराइट. I've answered your question. Answered. Okay. Okay. Please, all of you write down judicial admission, section 58. Facts admitted need not be proved. Need not be proved. तो कुछ इतना लिखवाने वाला है भी नहीं इसमें, बट फिर भी चलो. फैक्ट्स, नो फैक्ट need to be proved in any proceedings. No fact need to be proved in any proceedings in which the parties or their agents agree to admit a fact, put a hyphen, point number 1, at the hearing, or point number 2, which they agree to admit in writing before hearing, or third, which by any rule of pleading which by any rule of pleading they are deemed to have admitted, they are deemed to have admitted by their pleadings. They are deemed to have admitted by their pleadings. Change the paragraph. Those facts need not to be proved by the opposite party. Those facts need not to be proved by the opposite party.
But they can be disproved, right? But they can be disproved.
No, they cannot be. That's what I'm saying.
No, you said those facts need not be proved by the opposite party, but they can be disproved. Let's just say someone lies in the written statement. Someone, like, the complaint is that there is, I came to your house and
Understood
you.
what you're saying, Shreyansh. You're right. वो तो prove करना ही पड़ेगा ना.
Right. So वो अगर written statement में झूठ लिखा है तो that can be disproved by the other party, right?
But that fact need not to be proved by the opposite party. Prove करने की जरूरत नहीं है, but आप उसको rebut कर सकते हो.
Right.
Conclusive नहीं ना. You're right. ठीक है. Please, all of you continue writing. Those facts need not to be proved by the opposite party. Need not to be proved by the opposite party. Change the paragraph. Proviso to section 58 provides. Proviso to section 58 provides that the court may in its discretion, require the facts admitted, require the facts admitted to be proved otherwise than by such admissions. By such admissions. Then Order 8, Rule 5 of CPC. Order 8, Rule 5. Order 8, Rule 5 CPC provides that if the defendant omits to specifically deny any allegation, made in a plaint, he shall be deemed to have admitted it. He shall deemed to have been admitted it. Deemed admissions का जो हमने कल कॉन्सेप्ट लिखा था वहां पे आप ऑर्डर 8 रूल 5 भी लिख सकते हो बेटा. All of you can add order 8 rule 5. Nagin Das versus Dalpat Ram. Nagin, Nagin, Nagin Das versus Dalpat Ram. AIR 1974 Supreme Court. Supreme Court held that the admissions in pleadings or judicial admissions, Supreme Court held that admission in pleadings or judicial admissions admissible under section 58 by the parties, admissible under section 58 made by the parties or their agents, at or before the hearing of the cases, at or before the hearing of the cases are of high probative value. Probative value. Probative means evidentiary value. एंड यहाँ पे बेटा आप प्रिजम्पशन भी ले सकते हैं ना, 114A 114A एनीवे दैट भी उसको छोड़ दो, क्योंकि जब आपने कुछ एडमिट किया है तो कोर्ट प्रिज्यूम करेगी वो प्रूव्ड है, और अगर कोर्ट वो प्रिज्यूम करेगी वो प्रूव्ड है, तो दूसरा फैक्ट व्हिच शैल फॉलो आल्सो शैल बी प्रूव्ड, शैल बी प्रिज्यूम्ड बाय द कोर्ट टू बी ट्रू, राइट? दैट कैन बी फर्दर, बट एनीवे जो कल आप लोगों ने बेटा जो लिखा है ना साइलेंस में अमाउंट टू एडमिशन, वहां पे प्लीज राइट डाउन, यू हैव टू डिस्कस सेक्शन 58 judicial admissions. You have to discuss order 8 rule 5 CPC. Order 8 rule 5, it's talking about judicial admissions only. Okay, primarily it's talking about judicial admissions only. Clear? All right. So from here, we go to confessions now. I think we have covered every aspect of admission now. Now we go to confessions. Confession. The term confession is not defined, okay, beta? If you're asked, it's not defined anywhere. It's not defined anywhere in Indian Evidence Act, neither in BSA. I think this is section 22 of BSA. Debanj, 22.
Yes, ma'am.
Section 22 of BSA. And section 24 of Indian Evidence Act. इसमें एक डिफरेंस आया है बीएसए में, यहाँ पे उन्होंने एक टर्म ऐड कर दिया कोअर्जन. ओके, पहले ये टर्म कोअर्जन नहीं था. जो चेंजेस होते हैं अभी, जैसे हमने सीआरपीसी में क्या किया था बेटा, बीएनएसएस के सारे चेंजेस लास्ट में लिखे थे ना, यू रिमेम्बर? बट यहाँ पे बीएसए में देयर आर नो मेजर चेंजेस, वेरी फ्यू चेंजेस आर देयर. सो सिर्फ अभी 22 of BSA which talks about confession, and 24 of Indian Evidence Act talks about confession. 24 of Indian Evidence Act talks about confession. So the only change here is that they have added the term coercion under 22 of BSA. Rest everything is the same. Rest everything is the same. Only the term coercion has been added. Okay. I will explain, वो भी मैं बताऊंगी कि क्या उसका इफेक्ट है, बट पहले तो हम समझते हैं कि what is the definition of confession. Now, as I'm telling you that the term confession is not defined. It's not defined under Indian Evidence Act, neither in BSA. But क्या है confession? It is same as admission. Why am I saying it is same as admission? Because confession is also a statement only. Confession is also a statement. It is also acknowledgement. But when you're acknowledging your own guilt, then it becomes a confession. Did you understand? Admission, confession क्या है? Confession क्या है? वो भी एक statement है, वो भी acknowledgement है. बट यहाँ पे आप acknowledge कर रहे हो अपने guilt को. जब आप acknowledge करते हो अपने guilt को, तो वो confession बन जाता है, तो वो confession बन जाता है. ठीक है? बट कन्फेशन कौन दे सकता है, एडमिशन कौन दे सकता है? दैट वाज, ये तो हो गया स्टेटमेंट्स, ये हो गया आपका एडमिशंस, और वही बनता है आपका जब आप एक्नॉलेज करते हो अपने गिल्ट को, वो बन जाता है कन्फेशन. बट अब जो एडमिशन है वो कौन कौन दे सकता है? हु मे गिव एडमिशन? हु विल टेल मी? हु कैन गिव एडमिशन? कौन दे सकता है एडमिशन? 18, 19, 20. And who can give confession? only party. Confession is only made by a party, not by a third person. Who can give confession? Who can give confession? Only party. That's the difference. Only party can give confession, not a third party. Not a third party. तो अब सबसे पहले अगर हम डेफिनेशन की बात करें, डेफिनेशन को हम लेते हैं पकला नारायण स्वामी वर्सेस एम्परर का केस, वहां से हम स्टार्ट करेंगे, ठीक है? वहां पे इट इज बीन डिफाइंड। उसके बाद जो 24 ऑनवर्ड्स, अब यहाँ पे जो इंडियन एविडेंस एक्ट है, यहाँ पे जो कन्फेशन है, इट इज डिस्कस्ड फ्रॉम 24 to 30 ऑफ इंडियन एविडेंस एक्ट। 24 टॉक्स अबाउट irrelevancy of confessions, confession caused by inducement, threat or promise when irrelevant, irrelevancy. And one more thing that we have to understand, confession हम civil cases में confess करते हैं? Do we confess in civil cases? Yes, Akshita? No, na? Confession is in criminal cases. Admission, dono. Confession is in criminal cases. Confession in criminal cases only is at which stage? Investigation stage. ठीक है? All right. And these are which confessions? Extrajudicial confessions. Judicial confessions under 164 CRPC. These are extrajudicial confessions. ठीक है? जहाँ पे आपने डेफिनेशन लिखा है बेटा, वहां पहले डेफिनेशन लिख लो, एंड फिर उसके बाद आप दो पार्ट्स में डिवाइड करेंगे। बेशक सीआरपीसी में भी हम कर चुके हैं, एक्स्ट्रा जुडिशियल कन्फेशंस एंड जुडिशियल कन्फेशंस। Judicial confessions are under 164 CRPC. These are extrajudicial confessions. These are extrajudicial confessions. So please write down Pakla Narayan Swami versus Emperor. Pakla Narayan Swami versus Emperor. PAKLA. PAKALA. PAKALA. Pakla Narayan Swami versus King Emperor. Privy Council 1939. And the definition is given by Lord Atkin. The definition is given by Lord Atkin. ATKIN. Lord Atkin. Confession is the admission of the guilt by the accused confession is the admission of the guilt by the accused in as many terms confession is the admission of the guilt by the accused in as many terms, underline as many terms, underline as many terms, or the admission of such facts, or the admission of such facts which together constitute the offense. Which together constitute the offense. So if we understand what Lord Atkin is saying, Lord Atkin is saying that confession is the admission of the guilt by the accused, admission of guilt by the accused in as many terms. इसका मतलब क्या हुआ? What is Lord Atkin trying to say? In as many terms. You have to break this definition. Or, yes, the admission of such facts which together constitute the offense. Which together constitute the offense. Who's going to explain the definition?
I mean, as many terms means as comprehensive as possible.
Can you give me some example?
Like, let's just say if someone wants to confess a murder, then he or she needs to like be very comprehensive while the confession, where they were, what they have done, and everything, every fact of theirs should be needs to add up. They can't be like, kaha murder kiya, kab kiya, in what circumstances have you done the murder, everything. And everything should add up. That's what in as many terms and facts together constitute the offense. So everything should come together and it should paint a much like an absolute clear picture, which does not leave any reason of doubt.
Yes, somewhat you are correct. Let me make it more clear for others. See बेटा वो क्या कह रहा है? Confession क्या है? वो एक admission है, acknowledgement है. किस चीज का? आपके guilt का. But कैसे? अब देखो बेटा, अगर A ने खून किया है, या तो वो डायरेक्टली बोल दे कि मैंने जाके B का खून किया है. That is admission of guilt by the accused. He goes and says कि मैंने जाके उसका खून कर दिया है. या फिर he is not saying कि मैंने पहले एक स्टेटमेंट क्या दिया? A says I have committed murder. ये क्या है बेटा? Admission of the guilt by the accused. ठीक है. या फिर यहाँ पे क्या है? See, I have committed murder. I have committed murder. This part is admitting guilt. Admitting guilt. This is the admitting of guilt. Now, he may say, I had enmity with B. I fired upon him. I had enmity with him. I fired upon him. अब ये जो स्टेटमेंट है, इसको अगर आप रिफ्लेक्ट करो बेटा, here is A saying that I have killed B. Is he admitting the guilt? So what is Lord Atkins saying? What is confession? It is the admission of the guilt in as many terms, or the admission of such facts. You're admitting, na, I had enmity. You're admitting that I fired upon him. That together will constitute the offense. Are you understanding my point? Here
How
you are
does
saying that
this
you had
constitute
enmity, you were there, I fired upon him. Now here, the interpretation is that from these, ये जो उसने facts बोले हैं, you're not admitting guilt. You're not admitting guilt in as many terms. यहाँ पे you are admitting guilt in as many terms. यहाँ पे you're not admitting guilt in as, but you have admitted such facts which together constitute the offense. Which together constitute the offense. आपने ऐसे facts admit किए हैं, you're not admitting the guilt, but you have admitted such facts which together will constitute the offense.
Ma'am,
Which together.
how does these two facts, I had enmity with B and I fired upon him? So how does this conclusively say that he is the one who killed him?
It's
Like,
not saying conclusively. There's still a rebuttal. There's still a rebuttal. But he's saying,
so this
Lord
will
Atkin
not
is
be.
saying that even then it may amount to confession. If the facts that you're admitting constitutes an offense, you had enmity with him, you fired, and on that very point of time, that person has died because of the gunfire shot. It concludes that yes, there was an offense. That is also a confession. So a person may confess. Now see, confession, जब आप कोर्ट को कन्फेशन देते हो तब तो कोर्ट बहुत सारे डूज एंड डोंट्स, बहुत सारे गाइडलाइंस को फॉलो करता है ना. वो पूछता है आपसे, आप वॉलंटरी दे रहे हो या आपके खिलाफ यूज होंगी. ठीक है, आपको जरूरी नहीं है इन कन्फेशन को देना. अगर वो पुलिस कस्टडी में है तो कोर्ट विल मेक श्योर कि उसको जुडिशियल कस्टडी में डाला जाए. राइट, ये सारे जो है इन सीआरपीसी वी डिस्कस अंडर 164. ठीक है, तो जुडिशियल कन्फेशंस में तो हम उसको हमेशा वार्निंग देते हैं. बट इन एक्स्ट्रा जुडिशियल कन्फेशन a person may come and say, after he committed the offense, he may come and say to X person that, yeah, I had enmity with him and I fired upon him. That is also confession. Now that X person can come to the court and can he come and say to the court? Can he
Yes.
give? Yes. Yes. Did you understand? Now,
Ma'am, but that
Shreyansh?
will by the third person it will not be treated as a confession. By the third, when as in your example, if X comes and says this will be an admission, not a
That's a
confession.
hearsay.
Yeah.
ठीक है. All right. Now, can we just come to section 24 now? 24. It says admissions, sorry, 24, confession caused by inducement, threat, or promise when irrelevant in criminal proceedings. Underline the term irrelevant. Irrelevant. A confession made by an accused, underline accused person, is irrelevant in a criminal proceeding. Underline in a criminal proceeding. If the making, अच्छा criminal proceeding पे 2 मिनट रुको बेटा. एक चीज यहाँ पे नोट करो बेटा. Admission applicable to both civil and criminal. Confession only applicable to criminal. Estoppel, principle of estoppel primarily applies to civil. 3 चीजें हमने की है ना बेटा. ठीक है ना. तो admission, civil and criminal. Confession only to criminal proceedings. Estoppel primarily applies on civil cases. Okay. Then again in civil, sorry, a confession made by an accused person. Accused को भी underline करो. Admission is made by 18, 19, 20. Confession is made by accused person. Is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, or promise. Now they have added coercion here. Inducement, threat, or promise. Underline inducement, threat, or promise. Inducement, threat, or promise. Having reference to the charge. Circle this, इसके ऊपर star लगाओ बेटा. Having, because we generally do not apply this, we forget, but this is the sine qua non of the section. Having reference to the charge. This inducement, this threat, this promise, this coercion has to be in reference to the charge against the accused person. Proceeding from a person in authority, underline person in authority, and को circle karo, and sufficient in the opinion of the court, underline opinion of the court, to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of temporal nature. Temporal nature, temporal means material nature, in reference to the proceedings against him. In reference to the proceedings against him. Yes. So what is it saying? Okay. Now, I am giving you a flowchart for this section. Extra judicial confession. Okay. It's verbatim from the Bare Act only. Confession made by the accused is irrelevant if it appears to the court appears to the court. Point number one, that there is threat inducement, promise और coercion. Coercion में लिख लो added by BSA 2023. Then you please underline inducement, threat, promise, coercion, and then you divide it into two parts. और यहाँ लिखो A, in reference to charge, and बीच में लिखना and by person in authority. By person in authority. Has everybody followed till here? ये जो threat, inducement, promise और coercion है, it should be in reference to charge and it should be given by a person in authority. Then you please club this together. In the opinion of the court, in the opinion of the court, and it appears to the accused. And it appears to the accused that he would, again, two parts में, gain advantage or avoid evil of temporal nature. Temporal nature, you understand? Material nature. I will get acquitted. My punishment will be minimum in case I confess, right? So temporal nature means material. Written? Okay. So what is it saying? If you just look into this chart, it says confession is made by the accused. That confession, इसका ये section 24 है ना, यहाँ पे term लिखा है irrelevant. और यही irrelevant confession relevant हो जाएगी अगर 28 में आए. इसका जो flip side है ना, वो 28 में, counterpart is 28. So from section 24, we'll go to 28. Okay. So it says confession made by the accused is irrelevant if it appears to the court that there is threat, inducement, promise or coercion. If there is threat, inducement, promise or coercion, मतलब अगर एक पर्सन ने अपना गिल्ट को एडमिट किया है और कोर्ट को लगता है उसने वो गिल्ट इसलिए एडमिट किया है क्योंकि उसको किसी तरीके का क्या था, लालच थी। इंड्यूसमेंट मीन्स लालच, थ्रेट मीन्स आपने उसको डराया था, कोवर्जन मीन्स आप जोर जबरदस्ती से, कोवर्जन मीन्स फोर्सफुल, ठीक है। एंड प्रॉमिस, यू प्रॉमिस कि अगर आप कन्फेशन देंगे तो आई विल डू व्हाट, समथिंग रिलेटेड टू द चार्ज। नाउ दैट्स वेरी इंपॉर्टेंट। इफ द थ्रेट इज व्हाट, threat is that maybe the threat is or the inducement or promise is कि मैं तुम्हें 10 करोड़ दे दूंगा, I promise to give you 10 crore if you confess that I have committed murder, ठीक है। induce, is it, in that case is confession irrelevant? Yes, Akshita? If a person confesses because I told him that I promise to give you 10 CR if you confess, and he goes and confesses, is that confession irrelevant or relevant?
Ma'am, irrelevant. Irrelevant.
Irrelevant. Others? Irrelevant? Relevant. Why irrelevant?
Ma'am, because that is not मतलब खुद के उससे, that
तो
was
यहाँ
forceful.
वॉलेंट्री,
Voluntary है.
इसीलिए मैंने कहा कि प्लीज सब, एवरीबडी इंटरप्रेट्स और थिंग्स दैट if the confession is by inducement, threat or promise or coercion, it is irrelevant. No, the sine qua non is that threat, inducement, promise or coercion should be in reference to the charge. Charge matlab accusation. Threat should be in reference to the accusation. Promise should be in reference to the accusation. You confess, I promise कि मैं तुम्हें बाहर निकाल लूंगा, I promise मैं तुम्हारे को बेल दिलवा दूंगा, I promise कि मैं आपकी पनिशमेंट कम करवा दूंगा। अगर वो थ्रेट, इंड्यूसमेंट, प्रॉमिस, कोवर्जन is in reference to charge, only then that confession is irrelevant, otherwise it is relevant. That's why the sine qua non of this section is in reference to charge and should be given by the person in authority. Here the courts always interpret in person in authority as a person who has control over the mind of other person. यहाँ पे हम इसको liberal interpretation देते हैं. So please understand that threat, inducement, promise, coercion should be in reference to the accusation only. If it is not in reference to the accusation, then the confession is relevant. And if you see section 28 now, if you see section, then you will get more authority here. 28, nahi. 28. Please see 28. Confession made after removal of impression caused by inducement, threat, or promise relevant. If such a confession is, as is referred to in section 24, is made after the impressions caused by any such inducement, threat, or promise has, in the opinion of the court, been fully removed, it is relevant. Again, 29, confession otherwise relevant not to become irrelevant because of promise of secrecy. If such confession is otherwise relevant matlab not falling under 24. Not falling under 24 matlab confession was not given under threat, promise or inducement in reference to charge. तो वो relevant confession है. It does not become irrelevant merely because it was made under a promise of secrecy. तुम मुझे बता दो, मैं आगे किसी को नहीं बताऊंगा, और वो पूरा अपना अक्यूज जो है अपना गिल्ट बता देता है, तो वो कन्फेशन रेलेवेंट है. और इन
But that is
कॉन्सिक्वेंस ऑफ
extrajudicial,
डिसेप्शन
right?
प्रैक्टिस्ड ऑन द अक्यूज्ड पर्सन, वेट प्लीज, और ऑन डिसेप्शन प्रैक्टिस्ड ऑन द अक्यूज. डिसेप्शन मतलब आपने कुछ ट्रिक प्ले किया ताकि अक्यूज जो है कन्फेस कर दे फॉर द पर्पस ऑफ ऑब्टेनिंग इट, और इट वाज व्हेन ही वाज ड्रंक. अगर एक पर्सन व्हेन ही वाज ड्रंक and he confesses, relevant confession, or because it was made in answer to a question which he need not have answered. Self incriminatory questions को जो आपके आंसर्स देने की जरूरत नहीं, बट अगर आपने आंसर कर दिया है तभी भी, whatever may have been the form of those questions, or because he was not warned that he was not bound to make such confession and that evidence of it might be given against him. They are not judicial confessions, they are extrajudicial confessions. Extrajudicial confessions are given to whom? They are given
Third
to
party. Third party.
private person or police officer. And if they are given to a police officer, they are as it is hit by section 25-26. And if they are giving it to the private person, तो वो confession आपने कब दिए? When you are drunk under the promise of secrecy. They're all relevant confessions. They're all relevant confessions. Only then, only in one situation, confession would be irrelevant given to a private person. In case that confession is given in threat, inducement, promise, or coercion in reference to the charge. That's very important. जो in threat है, threat मतलब जो आपने डराया है उसको. अगर तुमने कन्फेस नहीं किया ना कि तुमने मर्डर किया है, तो तुम्हें फांसी की सजा हो सकती है. और वो जाके कन्फेस कर देता कि हाँ जी मैंने ही खून किया है. आप समझ रहे हैं? अगर तुमने कन्फेस नहीं किया ना कि तुमने रॉबरी की है, तो तुम्हारी 3 साल की सजा वो 7 साल कर देगा. इंड्यूसमेंट, लालच, आपने उसको कुछ लालच दे दिया, प्रॉमिस करा उसको, coercion, but it has to be in reference to charge. Please do not forget that any other kind of promise, any other kind of inducement, inducement क्या हुआ? आपने लालच दिया या आपने उसको ट्रिक कर दिया. ट्रिक is not actually inducement, but अगर आपने कोई deceitful means भी प्रैक्टिस की है और फिर उस पर्सन ने कन्फेस किया ना, वो भी एक रेलिवेंट कन्फेशन है. ये आपका प्री में भी क्वेश्चन आया है. A
Ma'am, so who
person
will
confesses
decide?
when he is drunk. I'll take your question, Shriyansh beta, and turn on your video. A person confesses when he is drunk. Is it a relevant confession or an irrelevant question? Confession. It is a relevant confession. It is a relevant confession. Did you understand? एक macro, अभी मैं उसको micro लेकर जाऊंगी और but अभी आपको macro समझ में आया? Now you ask your question, Shriyansh.
Ma'am, so who will decide whether it's deception or it's inducement or threat or
You have to
promise?
prove it in the court. आप बोलोगे कि इसने मुझे कन्फेशन दिया था कि इसने जाके खून किया है. But then other party, if he takes this defense that it was I did not confess, but there was a deception that was practiced on me. So even if you prove that
Deception
there
is
was a
no defense.
deception, it
No,
is. Hmm?
deception is not a defense. You cannot use deception as a defense. You can only use inducement, promise, or coercion or threat.
Oh, I'm talking about section 29, Shriyansh.
Yeah,
29 में अगर आप बोलते हो कि मेरे ऊपर डिसेप्शन प्रैक्टिस करके कन्फेशन दिया है मैंने, तो वो
that is
जो
not a defense.
डिसेप्शन है, इट इज नॉट अ डिफेंस.
Right.
Then your
Ma'am,
confession is relevant.
okay. So let's just say if I say कि नहीं ये इसने deception नहीं किया था, it comes under inducement. It comes under promise. As you
You
gave
can't
the
say, you have to prove it.
So, ma'am, as you said in the example कि तुम ये confess कर लो, मैं तुमको 10 लाख रुपया, 10 करोड़ रुपया दे दूंगी. All right. So you said that is relevant. How, that is not deception. That is a promise. But you will say कि no, I deceived him. मैं कोई देने वाली नहीं थी. मैं तो बस ऐसे ही बोल रही थी ताकि ये confess कर दे. But I will say that no, this is a promise. You made a promise. This is not what उसके बाद जो मैंने confession किया. That is not relevant. Right?
बेटा वो promise should be in reference to the charge. That's my point.
Yeah, it should be reference to the charge. So let's just say I've committed murder. There's a charge of murder on me. Right? And you say कि तुम confess कर दो that you're
In
murdered, I'll give you.
reference to the charge, see, if I'm giving you money, that how it is in reference to the charge. I'm
Ma'am,
promising you to pay the money.
so that I confess to the charge. So that is
Yes.
reference to the charge, right?
You're not
You're not
understanding this part.
you're giving me money for a reason. You're not giving me money for free. You're giving me money so that I admit to a charge that is leveraged against
So
me.
I gave you money. It is not money जो है ना, see, money से मैंने आपको induce किया है ना, but inducement is by money. Then it is a relevant confession. If inducement is in reference to charge, then it is irrelevant confession. I've induced you through money, na, that I'm going to give you money. Then
Right.
it is relevant. But inducement has to be in reference to charge.
What is in reference to charge, ma'am? Can you please explain it
I'm
again?
going to I induce you that आपकी जो सजा है, it is 10 years. I will reduce it to 5 years. Won't you be induced? If you confess, जो आपका accusation है, it will come down to 5 years. Non-bailable would be made bailable. That's why I tell you to keep your videos on. I can't see. You're not even. Yes, Shriyansh?
And I get it, but in reference to charge means a like a
Accusation.
accusation of an
Charge means
offense, right?
accusation.
Yeah. So, ma'am, even if murder, like let's just say, I'll give you money, you admit that a murder has taken, like you have murdered. So that is against a charge, right? That will not qualify against charge.
No, beta, you're not interpreting it correct. आपको समझ में नहीं आ रहा मैं क्या बोल रही हूँ.
Ma'am, you are saying that in reference to charge means कि सजा कम करा देंगे या फिर like I'll reduce a sentence, or if it's more, if the punishment of the offense is more, I'll make it less. But I think it in reference to charge also means any connection to the
No. Why there is connection? Has the legislature used the term connection?
no.
It has to be it should not be abstract. It has to be specifically with reference to the charge. The inducement, threat, promise, coercion has to be in reference to charge. That you're going to reduce it, increase it. There's a fear that, you may be punished
Ma'am, it's
to
in
death.
reference to the charge, not reference to the punishment. Charge means accusation, right? You're
Right.
accused of something.
Yes. So you're accused of rarest of rare case, but we'll make it to culpable. Okay?
Okay.
Yeah. Try to read it again. You'll definitely understand. Shriyansh. ठीक है बेटा?
Okay.
All right. Acha, then going further, it says in reference to charge, but that in reference to charge should be by the person in authority. Now, who is this person in authority? यहाँ पे लिख लो बेटा छोटा सा liberal interpretation. We will not give it a strict interpretation, but we'll give it a liberal interpretation. Now, what do you mean by liberal interpretation? We can say that any person who can change the mind of the accused. Who can change the mind of the accused? कोई वकील है, he can change the mind of the accused ना? He would say that अब देखो layman है, उसको क्या पता है bailable क्या होता है, non bailable क्या होता है, डेथ सेंटेंस कब मिलती है, 10 साल कब 5 साल हो जाते हैं, right? तो if one lawyer he gives inducement in reference to charge to a person and then he confesses, that confession is only irrelevant. Otherwise, the confession is relevant. Otherwise, the confession is relevant. Is it making sense to all others? Is there any gray area? Shriyansh, is it making sense?
Yes, ma'am.
Yes? See, I understand because you know what happens? Sometimes you're reading a concept for the first time. All these years you've been thinking that, any confession, every time in law school, how हम लोग कैसे पढ़ते हैं? Confession given under threat, promise or
Yes, ma'am.
inducement is irrelevant. This is how we study. And then now today I'm telling you a new concept that it is only in reference to charge. And this has a backing of section 29. 29 बोल रहा है कि कन्फेशन अगर आपने प्रॉमिस टू सीक्रेसी में दी है तो वो रेलेवेंट है, इररेलेवेंट नहीं है. अगर कन्फेशन जब आप व्हेन यू आर ड्रंक एंड देन यू आर कन्फेसिंग, वो कन्फेशन भी रेलेवेंट है. और ये कन्फेशन कौन सी है? और जो हम वार्निंग की बात करते हैं वो हम जुडिशियल कन्फेशंस की बात करते हैं, क्योंकि जुडिशियल कन्फेशन की जो एक एविडेंशियरी वैल्यू है वो ज्यादा है. एक्स्ट्रा जुडिशियल कन्फेशंस की एविडेंशियरी वैल्यू इतनी ज्यादा नहीं है. और जुडिशियल कन्फेशंस की भी एविडेंशियरी वैल्यू ज्यादा तभी है अगर वो बाकी के एविडेंसेस के साथ कोरोबोरेट कर रही है, एंड अगर कोर्ट ने प्रॉपर सेफगार्ड्स और जो मेथड दिया हुआ है उस मेथड के अकॉर्डिंगली कन्फेशन दी है. अगर एक पर्सन पुलिस कस्टडी से निकल कर आता है और उसकी कन्फेशन रिकॉर्ड कर देता है जुडिशियल मैजिस्ट्रेट, in that case even that will lose its evidentiary value. Not, are you understanding? Because there are some safeguards that even the judicial officer has to follow. So that's the only point. That's why you're finding it a little difficult, but otherwise the interpretation remains the same, that confession only given by a person under threat, promise, coercion in reference to the charge by a person in authority. by a person in authority. Then further it says, in the opinion of the court and it appears to the accused. कोर्ट के ओपिनियन में और कोर्ट और अक्यूज्ड को लगता है, अक्यूज्ड appears to the accused, not appears to the court but appears to the accused, कि अगर उसने वो कन्फेशन दे दिया ना जिसकी वजह से उसको इंड्यूसमेंट मिला है या थ्रेट प्रॉमिस दिया इन रेफरेंस टू चार्ज, he will gain an advantage. This appears to the accused. So gain advantage of what? The threat, inducement, promise, coercion that he has been offered. Avoid evil temporal. Avoid evil of temporal nature. He can avoid evil. Evil means जिस चीज से उसको नुकसान हो सकता था वो उस चीज को अवॉइड कर सकता है, और वो एक बहुत टेम्पोरल नेचर का था, मटेरियल नेचर का था. सो ये दोनों चीजें भी जो गेन एडवांटेज एंड अवॉइड इवल ऑफ टेम्पोरल नेचर, दिस इज इन रेफरेंस टू इंड्यूसमेंट थ्रेट प्रॉमिस, एंड दिस इज ऑल्सो इंड्यूसमेंट थ्रेट प्रॉमिस. In such a case, the confession is irrelevant. Confession made by the accused is irrelevant when आप ऐसे लिख सकते हो, confession made by the accused is irrelevant if लिखा ही हुआ है, if only if it appears to the court that the court infer कर सकता है. appears to the court मतलब क्या हुआ? appears to the court मतलब not proved but appears to the court. Are you understanding? कोर्ट को लगता है, कोर्ट में प्रूव नहीं हुआ है श्रेयांश, इट्स नॉट प्रूव्ड. कोर्ट को लगता है कि किसी तरीके का थ्रेट, इंड्यूसमेंट, प्रॉमिस और कोवर्जन से ये कन्फेशन ली गई है, और वो थ्रेट, इंड्यूसमेंट, प्रॉमिस जो है इट इज इन रेफरेंस टू द चार्ज एंड इट इज मेड बाय अ पर्सन इन अथॉरिटी. एंड उसकी वजह से अक्यूज्ड को कुछ ऐसा लगा कि मैं कोई बहुत एडवांटेज गेन कर सकता हूँ, या आई कैन अवॉइड द इवल ऑफ टेम्पोरल नेचर. इन दैट केस कन्फेशन इज इररेलेवेंट. बट अगर ये जो इंप्रेशन है, थ्रेट, इंड्यूसमेंट, प्रॉमिस, कोवर्जन इन रेफरेंस टू चार्ज बाय पर्सन अथॉरिटी, अगर इस चीज को हम रिमूव कर देते हैं तो यही कन्फेशन जो उसने थ्रेट में दी थी, प्रॉमिस में दी थी, वो रेलेवेंट हो जाएगी 28 के अंदर, अगर हम ये कंप्लीटली ये इंप्रेशन को रिमूव कर देते हैं. टू मेक इट मोर सिंपलर यू कैन ऑल्सो मेक दिस. सी जो आपने कन्फेशन लिखा है, ये जो कन्फेशन है ये दो तरीके की है. जुडिशियल कन्फेशन, एक्स्ट्रा जुडिशियल कन्फेशन. मोर एविडेंशियरी वैल्यू, लेस एविडेंशियरी वैल्यू. 164 CRPC, Section 24 to 30 Indian Evidence Act. To judicial magistrate, to private person and police officer. Are you understanding? Akshita? And when it is made to the private person, if it is made to the private person, तो हम सबसे पहला वो सेक्शन 29 से आपको स्टार्ट करना चाहिए. 29 कहता है कन्फेशन रेलेवेंट है. 24 तो स्टार्ट ही नेगेटिव से शुरू हो रहा है. Confession when will confession be irrelevant? Confession is irrelevant. वैसे कहता है confession is irrelevant if given by the accused, if it appears to the court and is given by the accused under threat, promise and so and so. 29 और फिर 29 के नीचे फिर आपको लिखना चाहिए सेक्शन 24 रेड विद 28. 24 में थ्रेट, इंड्यूसमेंट, प्रॉमिस, कोवर्जन इन रेफरेंस टू चार्ज. तभी मैंने कहा है 24 का जो सिने क्वा नॉन है वो इन रेफरेंस टू चार्ज है बेटा. थ्रेट, प्रॉमिस, इंड्यूसमेंट इन रेफरेंस टू चार्ज. तो यहाँ पे वो इररेलेवेंट है, और यही कन्फेशन 28 में जाके रेलेवेंट बन जाएगी जब हम ये सारे इंप्रेशन रिमूव कर देंगे. How many of you are confused? How many of you are confused? Okay, श्रेयांश, and सबसे simple topic है ये. Rest others are all having some clarity. Okay, very good. Shreyansh, ask your question. Students would answer.
Ma'am, when you said ki promise has to be in reference to charge, so you gave the example कि आपका 7 साल सजा है, हम उसको 5 साल करा देंगे. So isn't that actually comes not under in reference to charge? It comes under, it appears to the accused that he would gain advantage or avoid evil of temporal nature. So
So
ये जो
all
आपने बोला
together,
कि
na,
सात सात
they are not in different compartments. जब आपको
मैम
किसी ने, मैंने तभी तो आपको मैंने यहाँ पे क्या लिखा है, देखो स्क्रीन पर बेटा, गेन एडवांटेज के ऊपर मैंने लिखा है ब्लू से, दिस इज इन रेफरेंस टू इंड्यूसमेंट, थ्रेट, प्रॉमिस और कोercion. सिमिलरली मैंने अवॉइड ईवल ऑफ टेम्पोरल नेचर के ऊपर ब्लू से लिखा है ना, इंड्यूसमेंट, थ्रेट, प्रॉमिस.
So this has to be corroborated with promise that
Yes, so you can't, इसको आप, अब जैसे अगर मैं बोलती हूँ कि मैं आपकी सजा 10 से 5 करवा दूंगी अगर आप कन्फेस करके मुझे सच सच बताते हैं कि उस रात क्या हुआ था, कि आप इन्वॉल्व थे वहां पर, और फिर आप कन्फेस कर देते हो. तो अब ये एक तरीके, अब एक देखो, जब मैंने आपको कहा कि मैं 10 से 5 करवा दूंगी, तो एक तरीके का प्रॉमिस भी तो है,
yes,
और एक तरीके का इंड्यूसमेंट भी है.
yes.
Are you understanding? But then, ma'am, what is the difference between promise and inducement? Promise is 1 degree higher than inducement. You know, but they can go together also. They can go together also.
Okay, ma'am.
And
So
when
let's
you
just
are
say,
induced, then you would definitely think that, yes, I'm going to gain advantage or I'm going to avoid the evil of temporal nature.
yes, that you have made the accused to be accused को ऐसे नहीं लग रहा था. आपने बोला है तब accused को लग रहा है कि okay, my jail time will be reduced and I'll be avoiding evil of temporal nature, right? So,
Yes.
but let's just say, as you say, कि आपने अभी बोला कि I'll give you 10 CR, तुम बता दो सच सच कि क्या हुआ था. That's one thing. But then,
आप बेटा
as
ऐसे करो श्रेयांश, जहां पे आपने ये लिखा ना इन रेफरेंस टू चार्ज, इसमें ताकि आपको कंफ्यूजन ना हो, आप सिंपली यहाँ पे लिखो, आई एम टेकिंग, आप यहाँ पे लिखो ताकि आपको कंफ्यूजन ना हो, उसके लिए मैं आपको यहाँ पे लिखवा रही हूँ. यू कैन राइट डाउन इन ब्रैकेट, इंक्रीजिंग और डिक्रीजिंग चार्ज, इंक्रीजिंग और डिक्रीजिंग ऑफ चार्ज.
मैम तो
आप
अभी ये
पढ़ो, थ्रेट
मैम एक
in
inducement
reference to
promise.
increasing the charge,
Okay,
threat in reference to decreasing the charge, inducement
ma'am.
in reference to increasing or decreasing. Yes.
Okay, that doubt is cleared, but a new doubt is there. That अभी ये पुणे वाला केस हुआ था, पोर्शिया से 2 लोगों को उड़ा दिया था उस बच्चे ने. It was on headlines, like it was national news. So let's just say मैंने किसी को बोला कि तू जाके confession दे दे, and you confess to the crime that you have not committed, and I'll give you 10 CR. ठीक है, you confess to a crime that you, तुम बोल दो कि हाँ मैंने मर्डर किया, मैं तुमको 10 करोड़ दे दूंगा, तुम्हारे परिवार का ख्याल रख लूंगा. ठीक है,
श्रेयांश, वही तो
तो
मैं बता रही हूँ, ये जो कन्फेशन है, ऐसी तो कन्फेशंस होती हैं जो लोग करवाते हैं, तो उसकी बड़ी
right.
कम एविडेंशियरी वैल्यू है. कल यही तो अक्षता भी पूछ रही थी, दिस व्हाट शी वाज आल्सो स्टक. ठीक है ना, तो ऐसे तो confession is not a substantial or substantive piece of evidence. It needs to be corroborated with other evidences. This is what Akshita was also stuck yesterday. On the same area she was stuck. Now, if a person who has actually not committed crime would go and confess because he's been promised,
मैम बट judicial confession is of high evidentiary value. तो बोलते हैं कि जज के सामने जाके बोल
and
दे.
that too only if it has been given properly.
Right, but like आपने एक एग्जांपल दिया, उसमें बोला है कि मैं तुमको 10 करोड़ दूंगी, तुम सच सच
अब
बताओ.
मुझे
और
अपना डाउट बताओ श्रेयांश, you tell me your
मैम
doubt.
that is the difference. I want to know the difference between you saying कि let's just say you said कि मैं तुमको 10 CR दूंगी, you made a promise in reference to the charge कि तुम सच सच बता दो, मैं आपका सजा कम करा दूंगी, 7 साल से 5 साल करा दूंगी, आप सच सच बताओ। सामने वाला बोल रहा है कि नहीं, तू कन्फेस कर दे कि तूने मर्डर किया, मैं तुमको 10 करोड़ दूंगा, सेम प्रॉमिस, बट his thing is different. He's saying कि तुम जो तुमने नहीं किया है वो तुम admit कर लो, and you are saying कि नहीं, तुम जो सच सच है वही बताओ. What is the difference between these two, and which
Shreyansh,
one?
I will take this after the class. It doesn't have much
Okay.
relevancy. That's why. ठीक
Okay.
है ना? You stay back, beta. I will
Okay.
clear this doubt, you know. But otherwise, I will tell you. I will make you write this down. You'll understand, beta. Don't worry.
Okay.
ठीक है? Yes, Winnie, what is your doubt?
Ma'am, not a doubt, but like I think that I have the answer to Shreyansh's question. Ma'am, that relevancy of money being given, that will not come under confession, but it will fall under the offense of IPC, that the person actually gave furnished false information. So, in that context, like it will not be confession, but it will be a crime altogether.
वो तीसरा आ गया। अब तुम दोनों रुकना,
हाँ,
विनी और श्रेयांश दोनों रुकना। वो फैब्रिकेशन जो तुम बात कर रहे हो ना, you both stay back, okay? All right, I'll tell you. Now, here is everybody clear? In reference to charge means increasing or decreasing of charge. चार्ज का मीनिंग जिसको समझ में नहीं आ रहा है उसको आगे ब्रेक डाउन करके आप यहां लिख सकते हो, इन रेफरेंस टू द एलिगेशन, इन रेफरेंस टू द प्रोसीडिंग। अब जिसको इसमें कंफ्यूजन है कि मैम थ्रेट, प्रॉमिस, इंड्यूसमेंट इन रेफरेंस टू चार्ज बाय पर्सन इन अथॉरिटी, जब आपका ये वाला पार्ट हो गया, यहाँ पे आप एक लाइन अंडरलाइन कर लो, यहाँ ड्रॉ कर लो, और इसके बाद यहाँ साइड पे लिखो कि इसका इफेक्ट थ्रेट, प्रॉमिस, इंड्यूसमेंट गिवन इन रेफरेंस टू चार्ज बाय अ पर्सन इन अथॉरिटी, उसका इफेक्ट क्या होना चाहिए? इफेक्ट ही होना चाहिए इन द ओपिनियन ऑफ द कोर्ट इट अपीयर्स टू द अक्यूज दैट ही वुड गेन एडवांटेज और अवॉइड दिस। ये थ्रेट का इफेक्ट होना चाहिए, इंड्यूसमेंट का इफेक्ट होना चाहिए, प्रॉमिस और कोवर्जन का इफेक्ट होना चाहिए। क्या? कि कोर्ट हैज मेड एन ओपिनियन एंड इट अपीयर्स टू द अक्यूज्ड, it appears to the accused that he would gain advantage or avoid evil of temporal nature. Now please write down, ठीक है? इसको लिखो please. लिखो, confession is of two kinds. Confession is of two kinds. Judicial confessions and second, extrajudicial confessions. Leave some space. I think you can write it on your own. Extrajudicial confessions and judicial confessions. Extrajudicial confessions are always given to the police officers, in private persons, executive magistrates, etc. And judicial confessions are only given, ये आपका प्री का फेवरेट क्वेश्चन था अभी तक का, 164 में क्या पूछते थे? Judicial confessions are given to whom? Judicial magistrate or metropolitan magistrate? JM or MM? अभी metropolitan magistrate is, removed, so only judicial magistrate. So executive magistrate will fall under extrajudicial. ठीक है? Then I think you want me to give you a breakup of 24, or I can just give you the meaning. Breakup तो आप लिख ही चुके हो ना ऊपर, जो आपने चार्ट दिया है, that is the breakup of 24 only. Okay, that's the breakup. So you can just पहले आप ना meaning लिखो in terms के. Write down the meaning of inducement. Inducement. To persuade or to lure. Persuade, comma, persuade. Persuade, you understand? P-U-R-S-U-A-D-E. P-U-R-S-U-A-D-E. Persuade, comma, ल्योर, जैसे हम बच्चे को ल्योर करते हैं ना बेटा, उसको पर्सुएड करते हैं, बच्चा आपके पास नहीं आ रहा है तो यू गिव हिम सम कैंडीज, he'll be lured. You give him his favorite toy, he'll come towards you. बस उसी को कहते हैं हम इंड्यूसमेंट, फुसलाना जिसको हम हिंदी में कहते हैं, ठीक है ना. सो इंड्यूसमेंट मीन्स ल्योरिंग, इंड्यूसमेंट मीन्स परसुएडिंग. इफ यू गेट अ प्रॉब्लम बेस्ड क्वेश्चन, यू हैव टू आस्क दिस कि इस सिचुएशन में क्या ल्योर हो रहा है, व्हाट इज द थिंग बाय which the other person is luring him. That's why I'm giving you a breakup. Persuade or lure, or to attract, or to encourage. अब इन वर्ड्स में हम देखो प्रॉमिस नहीं ले रहे हैं, बिकॉज प्रॉमिस को आप अलग से लिख सकते हो, ठीक है ना. अब इसके नीचे लिखो प्रॉमिस, मीनिंग ऑफ प्रॉमिस, टू डू समथिंग इन एक्सचेंज, टू डू समथिंग इन एक्सचेंज. प्रॉमिस फॉर अ प्रॉमिस ना, व्हाट इज प्रॉमिस? You give me 50 rupees, I'll give you this candy. So promise for a promise, right? ठीक है. So promise is to do something in exchange. Threat, to cause fear, or to cause fear. Fear लिखो, क्योंकि अब coercion आ गया ना, तो अब थर्ड लिख लो coercion, to compel. Compel. और coercion के नीचे आप प्लीज लिखो BSA 2023 has added the term coercion as one of the acts causing a confession to become irrelevant, as one of the acts causing a confession to become irrelevant under section 22 of BSA. Okay. So I hope everybody is clear with the terms. Okay. फिर इसके बाद देखो, according to section 24, where the confession of an accused is obtained by practicing any inducement, threat, promise, or coercion in reference to any charge, underline, in reference to any charge or proceeding against him and such threat, promise, आप इसको ना ऐसे लिखो TPIC, threat, promise, inducement, coercion, ठीक है. आप यूज एब्रीविएशंस, बाद में आप पूरा लिख सकते हो. एग्जाम में कभी भी एब्रीविएशन मत यूज करना प्लीज, ठीक है. थ्रेट, इंड्यूसमेंट, प्रॉमिस और coercion from the person in authority, which causes a reasonable apprehension, which causes, underline causes का मतलब क्या हुआ, हमने cause को बहुत बारी हमने interpret किया है, especially ICA में. What do you mean by cause? How Mullah has interpreted this term cause? He says cause is effect. If I'm trying to deceive Shreyansh, But if he is not deceived, can he sue me for fraud? He cannot sue me for fraud. That fraud should actually have an effect that he has been defrauded. Are you understanding? So even if I'm trying to threat Akshita, but if there is no effect, then it is not threat. Then it is not, it will not fall under 24. Okay? So which causes a reasonable apprehension in the mind of the accused. In the mind of the accused. इस पूरे को अंडरलाइन करो, causes reasonable apprehension in the mind of the accused. ब्रैकेट में लिख सकते हो effect, जो मैंने चार्ट में भी आपको लिखवाया, effect. That he will gain certain advantage or avoid evil of temporal nature. Temporal means material, or avoid evil of temporal nature. Evil of temporal nature in reference to the charge against him. In reference to the charge against him, comma, then such confession cannot be proved against him. Underline. Cannot be proved against him. Then such confession cannot be proved against him. इसके नीचे लिखो example. Example. Where a police officer says to the accused, I will drop certain charges against you if you tell the truth. If you tell the truth. And the accused makes a confession. And the accused makes a confession. Upon such inducement, it will be inadmissible. नीचे लिखो note, mere religious or moral inducement threat or promise or coercion. Mere religious or moral inducement, threat, promise, coercion will not make confession irrelevant. Will not make confession irrelevant. जैसे confession obtained in the name of the God. तुम अगर आज confess कर दोगे तो तुम स्वर्ग में जाओगे. और वो confess कर देता है. तो वो confession relevant है कि irrelevant है? Relevant. It's not irrelevant. ठीक है? Okay. अच्छा, can anybody think of this rule जो भी हमने पढ़ा? Confession अगर आप ऐसे promise कर रहे हो कुछ तो relevant है, but if it is in reference to promise of charge only, तब वो irrelevant है. Why? क्यों legislature ने ऐसे किया? What is the reason? What can be the rationale? कि confession made under threat, promise, coercion, inducement in reference to charge only would be irrelevant. But अगर ये impression हम remove कर देते हैं, ये effect remove कर देते हैं, then that confession becomes relevant. Why?
Because it is not the power of the police officer or other person to punish the person or to charge the person, but it is the power of the judicial authority, or can say the judge, to
that is true. But if the confession is given under threat in reference to charge, तो confession को irrelevant कर दिया, otherwise relevant कर दिया. क्यों?
Because, ma'am, if this distinction is not carved out, sometimes a confession may be helpful for some other offense, and it will be akin to tying the hands of investigating authorities.
Because यहाँ पर भी ना, at least in reference to charge, we are not going to give him wrongful hopes, and also in reference to charge मैं कह रही हूँ, we are not going to give him wrongful hopes, and also we make sure कि see अब हम ऐसे तो नहीं बोलते हैं कि confession should be free and voluntary. एक तरीके का जो 24 का जो रैशनल है एक कन्फेशन को इररेलेवेंट करने का, वो रैशनल यही है कि कन्फेशन अगर एक पर्सन दे रहा है, इट शुड बी वॉलंटरी, इट शुड बी ऑफ अ वॉलंटरी नेचर. वॉलंटरी मतलब यहाँ पे वॉलंटरी को हम कैसे दे सकते हैं कि सी इफ अ पर्सन इज ड्रंक, मैम, तभी भी तो वो वॉलंटरी नहीं है. इफ यू आर प्रॉमिसिंग हिम सीक्रेसी एंड देन यू आर ऑब्टेनिंग कन्फेशन फ्रॉम हिम, तभी भी तो वॉलंटरी नहीं है. But 24 के अंदर in reference to charge, it has to be voluntary. In reference to charge, it has to be voluntary. You can't give him false hopes with reference to charge specifically. But otherwise, अगर आप 20, and otherwise also, even if you're giving it to the police officer, it is otherwise also hit by 25. It is hit by 25. Did you understand what did I say?
मैम, इफ अगर कोई एडवोकेट है वो अपने क्लाइंट को बोलता है कि आप कन्फेस कर दीजिए, हो सकता है कि कोर्ट आपकी सजा कम कर दे, तो वो तो उसमें बस वो बता रहा है ना कि हो सकता है कोर्ट, तो दिस विल बी रेलेवेंट और इररेलेवेंट. ही इज नॉट थ्रेटनिंग बट ही इज
वकील जो है ना, वो वैसे भी प्रिविलेज कम्युनिकेशन में आ जाएगा, अक्षिता. That statement cannot be proved. If anything, you're disclosing to the वकील. वो वैसे भी प्रिविलेज कम्युनिकेशन में आ जाएगा. ठीक है. अच्छा, आई वाज कमिंग टू द पॉलिसी पार्ट. प्लीज अंडरस्टैंड कि जो आपका 24 है और साथ में जो आपका सेक्शन 29 है, इनका पर्पस क्या हो सकता है? See, in respect to section 24, the legislature intent can be or is basically the जो इसका rational है 24 का, कि जो confession है it should be voluntary होनी चाहिए, तभी वो relevant मानी जाएगी, otherwise वो irrelevant मानी जाएगी. अगर हम 24 का पर्पस देखें. और अगर हम 29 को देखें बेटा, तो 29 जो है वो बोलता है कि कन्फेशन जो है उसकी एडमिसिबिलिटी जो है, इट शुड नॉट बी अफेक्टेड बाय द illegality by which it has been obtained. Are you understanding? And this principle is on the English law. English law में एक settled principle है that if a person confesses by obtaining illegal means or under illegal means, in that case the confession would still hold good and will not be irrelevant. Same principle we are following under 29 also. But 24 may specifically we have just taken out one bit of the entire cake, of the entire confession, that if the confession is in reference to charge specifically, it should be voluntary. But otherwise, if there are other means adopted to obtain the confession, it would be relevant, because those means will not render any confession as irrelevant. So इसके नीचे लिखो बेटा, the purpose लिखो इसका बेटा, purpose लिखो. The purpose of making confession under section 24 as irrelevant and inadmissible is that that the accused may not be induced by the pressure of hope or fear to confess the guilt without knowing its truth in order to obtain relief or avoid danger full stop. The confession thus must be free and voluntary. Change the paragraph. On the other hand, under section 29, confession is made relevant. If made under promise of secrecy, etc. Because section 29 is based upon the English law. That the admissibility of evidence is not affected by, underline, not affected by the illegality of the means by which it is obtained. Full stop. बाकी 29 को भी हम डिस्कस करेंगे. Did you understand, all of you, beta? Yes. Okay. Now we come to section 28. Please write down 28. ठीक है. पर्सन इन अथॉरिटी कौन होगा पहले 24 में? Who would be person in authority? Who all can be person in authority?
Anyone who can control the mind of the accused.
Exactly. Please write this down. A person having the capacity to influence the proceedings reasonably. Person having the capacity to influence the proceeding reasonably in the eyes of the accused. Good evening, Vishwajit.
Good evening, ma'am.
Good evening. Ma'am would take you to the other room, beta.
मैम अभी जस्ट वो खत्म ही हुआ था, हो गया वो वाला.
अच्छा,
तो
हो
मैं
गया.
जस्ट पहले इस पे आ गया था, तो मैं इस पे से करता हूँ.
अच्छा, ठीक है. All right. ठीक.
ओके मैम, थैंक यू.
Oh, thank you. Okay. So a person in authority would not be given a strict interpretation. It is not कि सिर्फ वो पुलिस ऑफिसर अगर आपको कहता है या आपको थ्रेट करता है, प्रॉमिस करता है, या फिर जज ही आपको थ्रेट करता है, प्रॉमिस करता है. जज की वाइफ, she also has a capacity to do what? She also has the capacity to influence the proceedings, isn't it? So that's why I told you that person in authority should not be taken in literal sense. It should not be taken in strict sense. Threat, promise, inducement, coercion can be given not by the person who's actually in authority. Who is actually in authority? The magistrate, na? But if the threat, promise, or inducement is even given by the magistrate's wife, that confession is also not relevant. Are you understanding? यहाँ लिख सकते हो example magistrate, comma magistrate's wife, the IO's wife, उसके बाद आप लिख सकते हो और कौन हो सकता है? The reader of the court,
Sarpanch.
right? The naib of the court, the officers of the court, right? So all these are people who they are all people in authority.
Ma'am, if it is some
So
village headman who has,
what, Amit?
they have caught, ma'am, if it is some village headman, they have caught someone, and meanwhile the police is coming, they say.
Yes, headman. तो इसमें आप एक note लिखो. Person in authority has to be given a wide interpretation. Person in authority has to be given a wide interpretation. That is, if the accused believes that such person can reasonably influence, if the accused person believes that such person can reasonably influence his proceedings, that person is in authority. That person is regarded as person in authority. Now change the paragraph and write down 28, section 28. If any confession which falls under 24, if any confession which falls under 24, it will be irrelevant but if the confession has been made after any such inducement, threat or promise, if the confession had been made after any such inducement, threat, promise, coercion, at the time when the magistrate believes, underline magistrate believes, that the effect of inducement, threat or promise was fully removed, then the confession will be relevant. And will be admissible. Change the paragraph. The magistrate oblique court has to satisfy itself before admitting the confession in the light of attending circumstances as to whether the said effect was fully removed or not. Are you understanding? What do you want? जब भी आपने लिखा और समझा section 28 को, can we say that section 28 is clarifying section 24? 24 क्या कह रहा है कि अगर confession has been given by the accused person in reference to, under threat, promise and so on, in reference to charge, that confession is irrelevant. And now what is 28 saying? वो कह रहा है कि वही confession relevant हो जाएगी if in case this effect is removed. So it is clarifying. And 29 is also doing the same thing. 29 कह रहा है आगे कि if the confession does not fall under 24, In that case, in spite of confession being given under promise of secrecy and so on, would be still relevant. So 28 and 29 are two provisions which are clarifying section 24. They are clarifying section 24. ये दोनों provisions जो हैं 24 को ही clarity दे रहे हैं. ठीक है? So is everybody clear till 28? Right? Now please write down section 29. 29 I'm not reading again from the bare act. ठीक है? आप please लिखो. Yes, Akshita? Okay, please write down. As per section 29, the confession is relevant. As per section 29, confession is relevant and admissible. Yes, Akshita, you have something to ask? Okay. As per section 29, the confession is relevant and admissible. And admissible. Underline relevant, underline admissible. If the person obtaining the question, if the person obtaining the confession, if the person obtaining the confession had not given the said warning to the accused, I'm repeating, as per section 29, the confession is relevant and admissible, even if, I think even I have missed, even if the person obtaining the confession had not given the said warning to the accused. Underline person obtaining the confession. Underline obtaining, person obtaining the confession. Had not given the warning to the accused. Full stop. Change the paragraph. However, if the confession is recorded by judicial magistrate, if the confession is recorded by judicial magistrate, then under 164 subsection 2 CRPC, 164 subsection 2 CRPC read with clause 4 or 164 expressly provides that the magistrate shall give the warning to the accused and read with 463 CRPC. This all interlinking we have done in CRPC, beta. I'm not repeating. 463, who's going to explain? 463.
Ma'am, if there is any irregularity in recording the confession, it can be done away, but not illegality.
Very good. Yes. So basically 463, 464 CRPC जो है बेटा वो बात करते हैं कि अगर कोई भी प्रोसीडिंग के समय कोई इरेगुलरिटी होती है ना, इरेगुलरिटी आप समझते हैं कि आपको एक सेट प्रोसीजर दिया हुआ है और जज वो प्रोसीजर को फॉलो नहीं करता है, उसको हम कहते हैं इरेगुलरिटी. वो इरेगुलरिटी क्या आपकी प्रोसीडिंग्स को विशिएट कर देगी ट्रायल को या नहीं करेंगे? तो 463 talks about irregularities which will vitiate or not vitiate. Yes?
Only
Not
if it goes to the root.
Yes, go ahead, Amit.
It will vitiate only if it goes to the root, has caused any miscarriage of justice.
If it goes to the
root of the matter, or it has caused injustice.
So can anybody tell me what is the side head of 463 CRPC? Curable irregularity or incurable? I think it is incurable. 462 talks about curable irregularity. Can anybody open CRPC? 463 CRPC is incurable irregularity. Yes, anybody who has seen it?
Non-compliance with 164 or 281.
Yes, तो वो incurable है. Incurable है. Incurable है ना अमित? Incurable है. Okay, beta. So, acha, let me, because the ones who have not done CRPC, what I'm trying to explain you here is ki, you know, there is a procedure by which you have to take confession. You know, then that has been stated under 164 subsection 2, subsection 4. There are some guidelines given to you in the statute itself, and there are some guidelines given by the judicial pronouncements. So you have to follow that. And similarly, आपको जो है section 200 and जहाँ पे आपको procedure दिया है 280
281
281, ठीक है ना, section 281 CRPC. ये 164 CRPC is to be read with 281, then 463. Then you will understand this whole part of confession, you know. So 281. So if there is non-compliance of this procedure, if you have not given warning to the accused and you have taken the confession, in that case, it is an incurable irregularity. Incurable irregularity आप समझते हैं, जो क्योर नहीं हो सकती है. कुछ irregularities जो है वो curable है, कुछ irregularities जो है curable नहीं है. Curable नहीं है मतलब the trial would vitiate. You're understanding? The trial would vitiate. So अभी यहाँ पे मैं आपको क्या लिखवा रही हूँ कि expressly provides that the magistrate shall give the warning. अगर आप 164 पढ़ेंगे, वहां पे स्पेसिफिकली दिया हुआ है कि जो कन्फेशन है वो वॉलंटरी नेचर का होना चाहिए. अगर वॉलंटरी नेचर का नहीं है ना कन्फेशन, then does not hold good in law. That's not a confession. You know, that's not a confession. ठीक है बेटा. तो but on the other hand 29 में क्या दिया है, 29 Indian Evidence Act में क्या दिया है कि even if the person is obtaining the confession, he does not have to give any kind of warning. Are you seeing the contrast? Okay, so that's the contrast I'm trying to explain. Okay, so magistrate shall give the warning to the accused and read with 463. Isko likho, read with 463 CRPC. All the students who have not done CRPC, and even if you have done it, please go through this interlinking today. Okay, na 463 CRPC. If such warning has not been given, it is an incurable irregularity. It is an incurable irregularity. And the confession will be inadmissible. Change the paragraph. There is an apparent conflict. Apparent means on the face of it. There is an apparent conflict. There is an apparent conflict upon this point between 164 CRPC, and 29 Indian Evidence Act. However, (164 CRPC) BNS में भी same है. BNSS में भी only the section is changed, but otherwise it's the same. Confession में warning देनी है. Okay, provision is the same. However, section 164 CRPC being a specific provision, it will prevail upon the general provision. It will prevail upon the general provision of section 29. Why am I saying that it is a specific provision? CRPC तो वैसे general procedure code है ना, criminal में तो procedure code CRPC है ना. But why it is a general provision, specific provision? Because under section 164 CRPC, only a confession can be recorded by a judicial magistrate. That is why it is specific. Specific है ना वो बेटा? Specifically if the confession is recorded by the judicial magistrate. But when you are reading all these sections under Indian Evidence Act 29, 28, 24, is it given? Has to be recorded by any specific person? So they are general provisions. Confession, admission of a guilt by the accused to whomsoever. whomsoever. Okay. So 164 being a specific provision, it will prevail upon the general provision of 29 if the confession has been recorded by the judicial magistrate, but in other cases, Section 29 will apply. Section 29 will apply, and therefore, if the confession has been taken by the private individual, then even without the said warning, the confession will be admissible unless it falls under Section 24. Indian Evidence Act. Did you all understand? बाकी 29 को आप एक बारी पढ़ना, बट आज का जो आपका होमवर्क है, प्लीज राइट डाउन द डिफरेंस बिटवीन, स्पेशली स्टूडेंट्स अपेयरिंग इन HP जुडिशरी, this question, and even Chhattisgarh I have seen, difference between inculpatory and exculpatory statements, difference between judicial confessions and extrajudicial confession, judicial confession and extrajudicial confession. Judicial confession and extrajudicial confession. And also you will write down relevant, irrelevant. नहीं, आप ऐसे करेंगे, आप लिखेंगे relevant oblique admissible confessions and irrelevant oblique inadmissible confessions. I'm repeating, relevant oblique admissible confessions and irrelevant oblique inadmissible confessions. इस वाले पार्ट को आप अभी होल्ड कर सकते हो, because let me complete 25-26. This part you can hold.